Welcome to the January edition of Casita Coalition's 2024 webinar series on ADUs and middle housing. I'm Rafael Perez. I'm Casita Coalition's board chair. A brief word about us. Casita Coalition is a cross-sector regional nonprofit. We believe that providing housing choice and opportunity for people of all ages and stages of life in every community is an essential foundation for a California where we all can thrive. We're grateful to Casita's major sponsors, Wells Fargo, the San Francisco Foundation, and the Chan Zuckerberg Initiative, as well as our webinar sponsors, the California Building Industry Association, AARP California, the law offices of Alan Matkins, the law office of Reuben, Junius Rose, and the Building Industry Association of the Bay Area. To save time, bio information for presenters will be in the chat. As a reminder, if attendees could use the Q&A feature for their questions, not the chat, it would be appreciated. Today's presenters and panelists are subject matter experts on condominium law in California and on ADU condo conversions and financing as practiced in Oregon, Texas, and other states. So I'd like to start off by quickly framing why this is important. I myself am a realtor, and there is a challenge out there with inventory, especially affordable inventory for homeownership. Homeownership is not being built. It's one of the least built type of housing types in California, for sale homeownership housing, and especially that which is affordable. I have clients who are well approved for mortgages and just cannot find inventory out there that matches the amount that they are qualified for. So that's why it is important to create new housing types. There's also flexibility for homeowners to have decisions and independence on how and what they do with their property, especially that has an ADU on it. So we just wanted to make sure that we created an opportunity that would give homeowners flexibility, that would create new home ownership types, and that would use what's already working well in other states and other parts of the country that never had a prohibition on the separate conveyance of ADUs. Right. So, while the law became effective on January 1st, ADU condo conversions are not allowed yet everywhere in the state. They are only allowed in cities and counties that have updated their local ordinance and opted in. So how can you encourage this to actually happen? It starts by reaching out to your council member. It starts by reaching out to your county supervisor. And encouraging them to opt into AB 1033's allowance. If you service or work with clients that would benefit from this, let them know that there's a demand, that there's a need in your community, that there's a shortage of affordable homes for purchase, and that you absolutely support the implementation of AB 1033. The more phones that start ringing and emails they start receiving and stories where people will benefit in their communities, the more likely they are to prioritize the adoption. So with that in mind, I'd like to introduce our first presenter is Jay Drake, partner at Reuben, Junius Rose. Thank you.
Thank you, Rafael. Good morning. I'm going to provide an overview of AB 1033. As Rafael mentioned, it became effective on January 1st, 2024. AB 1033 primarily amends California Government Code Section 65852.2. Prior to the enactment of AB 1033, the sale of accessory dwelling units separate from the primary residence on the property was basically prohibited. It was only permitted under limited circumstances involving an ADU constructed by a qualified nonprofit corporation a low or moderate income buyer, and a recorded tenancy in common agreement. Now, with the passage of AB 1033, local agencies are authorized to adopt a local ordinance that allows the separate conveyance of the ADU and the primary residence as condominiums. AB 1033 includes specified requirements that any such local ADU ordinance must follow. Within the framework established by AB 1033, local agencies have leeway to craft their own ordinances. Next slide, please. Establishing ADUs as condominiums means that the subject property becomes a small condo project. The primary dwelling and the ADU each become a separate condo unit. As with any condo project in the state of California, the two primary laws governing condominiums and subdivision mapping must be complied with. The first is the Subdivision Map Act. AB 1033 requires that the condominiums are created in conformance with the Subdivision Map Act and the local subdivision ordinance. This basically means that a subdivision map for condominium purposes must be approved by the local jurisdiction. Typically, this would be a parcel map, and the map must be prepared by a licensed land surveyor. The map, once approved, must be recorded with the county recorder prior to conveyance of any condo unit. The second is the Davis-Sterling Common Interest Development Act, which is the primary state law governing condos. AB 1033 requires that the condominiums are created pursuant to the Davis-Sterling Act. There must be CC&Rs, which is the primary governing document for all condo projects in the state. CC&Rs cover standard issues such as easements, maintenance, cost sharing, use restrictions, mortgagee rights and protections, and dispute resolution. There must also be a condominium plan. The condo plan shows the units and all common areas on the property, typically including parking areas, yards, patios, that type of thing. The condo plan must also be prepared by a licensed land surveyor. Both the CC&Rs and the condo plan must be recorded with the county recorder prior to conveyance of any condo unit, as with any condo project in the state. There we go. AB 1033 requires that before recordation of the condominium plan, a safety inspection of the ADU must be conducted as evidenced through either a certificate of occupancy from the local agency or a housing quality standards report from a building inspector certified by the U.S. Department of Housing and Urban Development. This requirement addresses concerns that some ADUs, particularly existing ADUs, may not have been constructed in compliance with local building and life safety codes. These units will need to be inspected accordingly and evidence of the inspection submitted to the local agency. The local jurisdiction will decide how this requirement will fit into their process and which local agency should receive the safety inspection documents. For new construction ADUs, this should be less of an issue as the local building department will already conduct an inspection and issue a certificate of occupancy. Lien holder consent is required for the subdivision map and the condominium plan. AB 1033 states that neither a subdivision map nor a condominium plan shall be recorded without each lien holder's consent. The lien holder may refuse to give consent, or the lien holder may consent provided that any terms and conditions required by the lien holder are satisfied. Now, lenders are already required to sign condo plans in the state pursuant to Civil Code Section 4290 and certain subdivision maps already. So this should not impose much of an additional burden. Many lenders are used to reviewing and signing condominium plans and subdivision maps. Prior to recordation of the condominium plan, written evidence of the lien holder's consent must be provided to the county recorder along with a specified signed statement from each lien holder. The lien holder's consent may be included on the condominium plan or on a separate form attached to the condominium plan that also includes specified information about the property, property owners, and lien holders, and shall be recorded with the county recorder. AB 1033 includes some required language for those consents. The local agency shall include a notice to consumers on any accessory dwelling unit submittal checklist or public information issued describing the requirements and permitting for accessory dwelling units. The AB 1033 includes required language for this notice to consumers. The local agency may determine the specifics of how the required notice will be provided. If an ADU is established as a condominium, the local government shall require the homeowner to notify providers of utilities, including water, sewer, gas, and electricity, of the condominium creation and separate conveyance. The local agency may develop a form of notice for this purpose. The local agency may require a separate utility connection for an ADU upon separate conveyance of the ADU and primary residence. The extent of the utility separation between an ADU and a primary residence is not specified. Certain utilities may be easier to separate than others. Submetering may be sufficient to satisfy this requirement. For existing HOAs, the owner of a property or a separate interest within an existing plan development shall not record a condominium plan to create condos on their property without express written authorization by the owners association, the HOA. Pursuant to Civil Code 4751, which is already existing, the HOA of a planned development cannot prohibit or overly restrict an owner from constructing an ADU on their separate lot. So ABU adds to that and makes sure that an owner must still get the approval of the HOA for the ADU. And to clarify, this applies to existing planned developments, not existing condo projects. Existing condo HOAs appear to have more authority to impose requirements on approval and construction of ADUs. Now, we've developed some sort of guidance, some required steps and recommended steps to implement the sale of ADUs as condos. The first one, the first three are required, and of course, to eliminate any sale restrictions, the local jurisdiction should remove all provisions in the municipal code that prohibit the sale or other conveyance of an ADU. These restrictions are typically included in the local condominium or subdivision code or the zoning code. Then also, of course, to adopt legislation expressly allowing the ADU sales. To align the local rules with the state law, the local jurisdiction should adopt changes to the municipal code that allows conversion of a home and its ADU into condominiums, subject to the requirements of the Davis-Sterling Act. And also, the local agency must include the required consumer notice on the pre-application checklist or other materials. Again, that notice is described in AB 1033. And then recommended steps are to publish ADU checklist, provide a comprehensive checklist for any ADU building permit and for ADU condominium subdivision projects. This will help to avoid confusion and answer questions that I'm sure there will be many from these prospective ADU builders. And something to consider, not require, but something to think about is to offer to impose a first right of offer to owner occupants. So to further encourage new home ownership, consider including a condition of approval for establishing ADU condos that would give a first right of offer for a period of 45 days to owners intending to occupy the home themselves or their immediate family. This would mean they would have the first choice to buy these units, these owner occupants. And then other ways to promote the ADUs would be to incentivize the ADU condo conversions with expedited processing, waived or reduced fees. And that is the end of my presentation.
Up next, we have Julie Alexander. Thanks, Jay.
Hi, thank you for having me. My name is Julie Alexander, and I'm a condo attorney in Austin, Texas. I did my first 2-unit condo regime almost 20 years ago. So I've been doing ADU and duplex condos as well as larger projects for almost 20 years. I've formed easily over 2,000 ADU condos in Texas, mostly in Austin, but also in San Antonio and some of the other metro areas in Texas. And probably about half my clients are from California, maybe more. And the conversation always starts something like this. What's involved? How long does it take? What are you not telling me? Because the condo conversion process in Texas is still very much, I think of it as the Wild West of condo conversions. And that's not to say Texas is easy and sorry, California is more difficult, but I think that there are a lot of lessons to be learned from seeing this unfold in Texas without as much regulation. And so my purpose here today is really to talk about how it works in Texas, how ADU condos are helping in Texas. And I'll start with how it works in Texas. So in Texas, condo regimes, or the right to convert a property into condo units, is an entitlement under state law. And so if you can build it, you can convert it to condominiums. We have the same laws whether you have 2 units or 200 units. So we have the same laws whether you're converting an apartment building or an ADU and main house. There is no municipal approval or no city approval. So it's not a question of whether or not it can be done. It can be done because it's done under state law. And our building codes also allow for flexibility in the layout. This picture here is an example, a very common setup in Austin, which is you have the main house with access off of a main street, and then you have the ADU with alley access. And so that allows for really clear division between the units as far as ownership. And what that allows me to do is to structure projects like this in the photo as site condominiums, which is a federal lending term for the way in which the unit is defined. And so when I approach a project, I always know that these buyers are not really condo buyers. They're not comparing this property to those buildings you see in the distance downtown. They are single family home buyers who have been priced out of these neighborhoods. They see this product come on the market. They don't understand it's a condo. They don't really want it to be a condo. So I try to structure my condo regimes for these types of projects to function as much like a single family home as possible. And sorry, I didn't start my timer here. Another nice thing that I can do in these sorts of projects is, well, let me go back. So the site condominium is where the house and the yard areas are defined as the condo unit. And What that does is it allows for um, easier financing for buyers. So there's exceptions in Freddie and Fannie rules for site condominiums as well as 2-unit detached projects. But it also protects the seller or the developer by providing additional liability protection. It's all kind of, the devil is in the details with the way you structure these documents for liability protection. And we all know that condos get a bad rap for having lawsuits associated with them. So this is one way to help avoid that. Another popular thing that I've been doing over the past, well, I've been doing it for a long time, but it's become increasingly popular in Austin, is to take a tool that I use for bigger projects and apply it to these small unit projects, which is to reserve development rights to sell the main house, or reserve development rights to build a unit. So you could do a condo regime at any point in the process. You can do it with an existing unit, a unit under construction, or just raw land. And so if you have a main house, but you can't get a partial release from your mortgage holder to build the back unit, I have a lot of clients who sell the main house and then use that money to build an ADU in which they live. So they are able to stay on the property that way. I'm going to move on to the next slide. Sorry, go back, Tim, to the one side by side. How to structure a condo regime to feel like a single family home. So this is a good example of, this is an ADU in this picture where the units are side by side. And so they don't always have to be front back. When I approach these 2-unit condo regimes, what I'm really trying to do is to end up with no dues, no monthly dues. So we are able to do separate hazard and liability policies with single family policies so they get better coverage at lower rates. We don't do a 3-person board, even though there's a nonprofit corporation as part of the HOA, because that doesn't work in 2 units. You really need to push decisions down to the owners and have those made typically 50-50. Because if you do a smaller percentage for the ADU, they're always going to be outvoted. Each person maintains their own house and yard. Okay, Tim, I'll move on to the next slide. So how are ADU condos helping in Texas? How they're helping is they're providing thousands. In my practice, I've created over 4,000 of these types of units over the past 20 years. And so they're providing a lower cost entry point for people who want to own homes in Austin. There's a huge demand for ADU condos. It is very rare that if both units are for sale, that the ADU does not sell first. The sale of the main house often allows someone moving into the ADU who wants to stay on the property to stay in their house and live mortgage free or with a smaller mortgage. It allows families flexibility to live together on the same lot, but to own separately, to have the ability to finance separately and to decide when to sell separately. Austin recently also allowed 3 units by right at the end of last year. So that's going to drastically change the way that properties look in Austin. I've already been doing 3-unit condos this year. I'll move on to the last slide. One thing I wanted to address is institutional systems. And I think that a lot of the resistance I see to ADU condos is not so much the concept of the ADU condos, but to the institutional systems. And, they take time to adapt, but change is happening, and change has been happening over the 20 years I've been doing this, and it's more rapidly happening recently. I think first of all, and most important, the needle is moving in cities across the country, and I'll talk about Austin, to allow easier building codes to incentivize building ADUs, or now we're going to have 2 ADUs. Texas also came very close to passing a statewide law last year allowing ADUs by right. The partial release approval process for mortgage holders, so that's when you own a property and you're trying to get one of the units released for sale from the mortgage, that's improving. It's still onerous, but I think that lending is catching up with the idea that condos are not this bad destabilizing thing to happen to a property, and rather they increase value on the property. the bank lending, so like local banks, credit unions, they're caught up for the most part in Texas, and they realize the value that that ADUs are adding to their security interest, and so they're making financing much easier for all people, for people who want to build an ADU and stay in their home, for developers, and so that's often a good option for my clients. Insurance options have gotten much better. I can do separate policies in 2-unit condo regimes, whether the units are attached or detached, which is great because we used to have to do a condo master policy, which was more expensive for worse coverage. And finally, yeah, lending, I guess lending options have improved. So the biggest change I've seen is that in the past few years, mortgages for buyers of these 2-unit condos have really loosened up. So I'm rarely getting condo questionnaires anymore. Typically, lenders are not reviewing condo docs, which that's probably a whole other topic, good or bad. But what it's doing is it's making it much easier for these units to sell and close. So thank you for having me. I'll end there.
And next up, we have Julie Felsman.
Mute myself and share my screen. So hopefully you can see my screen. I'm going to start a couple of timers so I can keep on time. So thanks for having me. There's a little bit of overlap with what some of the other folks have talked about. And first things first, I guess I just wanted to start by reiterating some of what both Jay and Julie said, that, once you convert an ADU to a condominium, it is, even though it looks the same, nothing's changed physically, it is not an ADU anymore. It's a condominium. And that means that it has to be conveyed and financed separately. And Julie touched on this just a moment ago, so I'm going to kind of piggyback on it and say that there was a lot of, as AB 1033 was being discussed, there was from some side conversations that Casita Coalition involved me in, I noticed some real confusion over the condominium guidelines. There are 3 paths in lending. What I do, I'm a residential loan officer, to financing condominiums. And one of them is a full condominium project review. And this is not even all the guidelines. Looks like my little scroller isn't working, but that was a long set of things that wasn't even the full guideline. We also have something called a limited review, and the guidelines are shorter, they're smaller, but there are a lot of ineligibles, a lot of knots that we still have to go through, and it can get kind of complex. But when you are when a property is either a detached condo unit, what Julie referred to as a site condo, or it's in a 2 to 4 unit project, literally the only things we have to do are meet insurance requirements and not be a hotel or a timeshare and not have any unaddressed critical repairs. That's it. And the appraisals are also very straightforward. If a property is detached, if the project is solely detached units, like some of the photos that Julie showed, then we actually appraise these on the single family form, the same form that we use for single family properties. And we use single family properties as comparables. The appraisers use single family comps. That's not true if it's an attached condo. If there are any attached units in a condo project, then we do appraise it as a condo. Now, I wanted to touch briefly on the motivations for converting to condos because, ADUs are expensive to build and design, right? And then you're converting to condos, that adds expense. In Oregon, I mostly hear it's between $20,000 and $30,000 for everything. That's complexity. It impacts taxes. So why on earth would somebody want to do this? Well, if you're a homeowner, as Julie called out, you can separately own and finance things. It is awkward, even for family members, to co-own one property with one legal description, with one mortgage. I'm sure all the California folks have tick stories that they could tell. And of course, you can also sell that unit to pay off debt. And I'm going to show a case study about that. And then in Oregon, a lot of our condominiums, not all, but a lot of them are being developed as by developers. They are really, it's become a business model. And I wanted to touch on a couple case studies. I had a third one, but I want to keep really tight to time, so I'm only going to show 2. The first one of these was actually developed by a developer. And so the middle unit, Unit A, was an original 1940s, kind of ranch house. And then those 2 other units, B and C, were condominiums that were developed. And a little quick timeline, the original owner purchased the property in 2014 and sold to the developer in late 2021, who then in early 2022 began the condo development process, recorded the plat in 2023. And I actually wanted to show the plat just so you had a visual of what this looks like. This is the survey that was performed to, do the magic and turn these, previously house with 2 ADUs into what are actually legally separate condos. And the house was sold for $612,000. The condos were sold in the mid 400s. And this is in the Woodward neighborhood of Portland, Oregon, South Tabor neighborhood of Portland, Oregon, where median sales prices are about $560,000 in 2022. So you can see those condos were sold for like a substantial discount, as Julie talked about. These are folks who were first-time home buyers, priced out of the neighborhood, were able to buy these ADU condo conversions. Now, I want to talk about another case study that's near and dear to my heart. This was an original kind of a Victorian farmhouse that a dear friend of mine owned. And this is the ADU that is built where her garage used to be. So she purchased the property back in 2004 and demoed the garage in 2016 and prepared and built her ADU through the course of 2016. She actually moved into it, rented out the front house, and then started the condominium conversion process in 2020. And COVID got in the way, didn't actually finish the condo conversion process until 2021. I know it slowed her roll quite a bit, but she recorded her plat, the condo conversion in 2021, and then sold the front farmhouse. She was tired of being a landlady with a 1902 farmhouse that she was maintaining, sold that for $487,000 and used the proceeds to sell her home. If we compare the sales price for that front house, which was actually the house, not the condo, in the Selwood Moreland neighborhood, where the median price in 2021 was $640,000, she sold that at a 30% discount to what houses sell for. And Alex is a dear friend, so I thought I would let her speak for herself. I emailed her. She was excited that she had the opportunity to just say what a life-changing thing this was for her. She is in her 80s and was enabled her to pay off her mortgage, live mortgage-free, and have this perfect place to age in place. Now, I do want to circle back to something and maybe lightly disagree with some of what Julie and Jay said when it comes to the provision in 1033 that requires a lien holder's consent. I would hope that as municipalities adopt this rule, some reasonable accommodations are made for people who intend to pay the mortgage off, because there are really, again, we said 2 motivations: separating ownership and debt, or paying off your mortgage. And so if you want to, let's say, separate ownership and debt, if you've got an existing joint loan, and that's awkward for you and your mom in the backyard to have, or you and a friend to have, if you can't get consent from your lien holder, and I will say from experience, I don't know anybody who's requested consent and got it. And I know, at least a half a dozen people who have requested consent and either didn't get any feedback or it was denied. Then you can't take that straight path that you want to take to refinancing the property. And this is important because if you don't have consent and you can't record the plat map, then I can't get a title report and create the new loans that these folks want to refinance to. So they're going to be forced to find money, take a temporary loan out to pay off their existing indebtedness in order to record the plat, let me get my title report, and record the refinance that I want to record. And I've done a number of these types of transactions for folks. Temporary loans are very expensive. So if you have a rich uncle who can lend you this money, awesome. But if you have to go get this from a lender, you're going to be dealing with a hard money lender that's going to charge you 3 points and a 12% interest rate, which is a really big expense for kind of getting from point A to point B in this circuitous route. And if you're Alex and you just want to pay your property off, and Alex had a first mortgage and a second lien, and I'll say that just as a footnote, backstory doesn't matter, we don't have a lot of time, but Alex tried to get consent from both her first mortgage holder and her second lien holder, and she's a real estate professional, had great attorneys guiding her through the process, and she was unable to get that consent to be able to list and sell and pay her loan off. They figured out she didn't ultimately need the consent. It was all about just getting clear marketable title to the property. But had she been blocked from being able to do that, again, she would have had to probably spend, I estimated she owed about $330,000 as she did this condominium conversion. Selling the house was more than enough money to pay that off, so she was easily able to provide marketable title to her seller. But she would have probably spent about $20,000 of her equity on a temporary loan of the nature that she would have had to get to sort of work around her inability to get that. She was, as an example, someone who was unable to get that consent. I think I actually got through all that on time. So I will cede my time early, and then if anybody has questions about that, I'll circle back to it. So I'm going to go ahead and stop my share.
All right, thank you. And now I'd like to welcome all our presenters back for a roughly 15-minute Q&A. Attendees, please use the Q&A feature for your questions, and if you could keep them general, that would be most helpful. We're joined by Linda Rios, consultant to the Local Government Committee of the California Assembly. The Casita team worked closely with Linda as part of Assemblymember Ting's legislative team to get Assembly Bill 1033 drafted and passed. Linda, why was this effort important to Assemblymember Ting and other legislators?
Hi, Rafael. Thank you so much to the Casita team for having me. Before I know the question is like, why is this important to the legislature and why is this important to Assemblymember Ting? Before I answer that question, I need to, make this statement just so that I don't get in trouble with my job. But I no longer work for Assemblymember Ting, so I cannot make any comments on his behalf. Any comments that I make from here on out is not a reflection of my new boss, Assemblymember Carrillo, or the Assembly Local Government Committee's position on any issue. It's just my observations and my experience. But to answer your question, right, my time with Assemblymember Ting, he has been a person that is really motivated by efficiency. He sees a problem, he wants it fixed, right? In California, it's no news to anyone that we are in a housing crisis, and it is one of the most unaffordable states to live in. LA, San Diego, San Francisco, the Bay Area, Silicon Valley, even Sacramento is becoming more and more unaffordable, especially if you're a government worker like me and you eventually want to be able to own a home. It's getting harder and harder. And so he was also a dad. Many of the legislators are parents, or they have very young staff members like myself that are, millennials or part of Gen Z. And as they're seeing that their staffers are kind of resigned to, maybe I won't own a house in my lifetime in California. And so there's this motivation to create housing solutions that are affordable, that are flexible, and that can fit in a variety of communities at a state level. So ADUs have created that solution in the fact that neighborhoods and communities have opened up their doors, either willingly or by force, due to the state's action on requiring that ADUs be approved by right and everywhere across the state. But ADUs, in the sense that they're smaller units, have allowed for denser development across the state, especially in communities where it has been difficult to build the housing needed to address affordability concerns and housing production goals. 1033 leverages the power of the ADU and opens it up as a homeownership option, which allows people to buy into the communities that they grew up in, the communities they want to live in, or just generally be able to age in place, as Julie mentioned, or provide financial independence or a safety net when crisis strikes. For example, a lot of people in California, in addition to facing affordability requirements, or affordability concerns, they may be on the cusp. They might own a home, but they may be on the cusp of losing everything because of a medical emergency. Being able to split up your property can give you that little nest egg to, one, stay in your own home and address emergencies as they come up. So 1033 was a really revolutionary way of addressing, one, the housing crisis, affordability crisis, and providing more financial flexibility and independence for Californians across the state.
Thank you for that, Linda. We are also pleased to welcome John Kevlin, partner at Reuben, Junius Rose. John, state ADU law has a specific clause called subdivision G, which says that the local agency can be more permissive than state law. How might that play out for ADU condos in cities or counties who want to encourage this new pipeline of homes for homeownership purchase?
Yeah, thanks, Raphael. Good to be here, and thanks to Casita Coalition for putting this on. It's subsection G. It's got its own name now. 1033, as we all know, is not a standalone statute, right? We have, through its enactment, amended the existing state ADU law to create this second path of separately conveying interests in ADUs. And so what it does is that it plugs into a larger framework of the ADU law that was in existence, prior to January 1st of this year. And now that we've spent all the effort of getting 1033 through the legislature and enacted, now we're working on implementation. And one of the really interesting areas of how AB 1033 connects with the ADU law is, as was just mentioned, subsection G of the ADU law, which basically says ADU law supersedes local regulations, and also it does not stop a local jurisdiction from being more permissive in order to for the creation of ADUs. The state in general right now is wanting to be very supportive of housing and housing development in all various different kinds of ways. HCD has already provided us some real benefit with respect to the ADU law, and that it's put out a guidebook, providing feedback and interpretation of the ADU law. And it's even loosened subsection G a little bit more subtly, but importantly, in that subsection G says local laws can be more permissive for the creation of ADUs, and HCD has put out guidance that says they can pass more permissive regulations to further the creation of ADUs. So subtle but kind of important broadening of that language to say not just it can be more permissive for the direct creation of ADUs, but really for the furtherance of ADUs. And that's what's really interesting about where 1033 plugs into all of this, right? Because whereas setbacks on ADUs, height limits, those are kind of easy to kind of apply. We're really dealing with a lot of complex systems when we're talking about applying condos in the ADU context. Beyond just the land use issues, we've got condo mapping issues, HOA issues. Even outside of the legal context, we have the lender markets and how those work and interact with ADUs. So it's not absolutely clear how subsection G applies to 1033. That's not a terrible thing, right? From a lawyer's perspective, that means we've got the ability to advocate creative and positive ways to interpret and apply 1033 and subsection G in order to continue to further the creation of ADUs. And so we've already, now that we've passed 1033, great, we're now turning our attention to implementation. And what does it mean that a local jurisdiction could enact a more permissive approach to the condo of ADUs? I think the conversation amongst the Julees and Jay highlights a really important area where we want to focus on, which is how do we make the lender can we make the lender consent more permissive? Can we, the goal is to facilitate these ADUs and the condo of the ADUs to facilitate that and happen more easily? How do we figure out the issue that Julie F. pointed out in terms of working with lender consent in a practical way that actually works in the real world? One of the things we've heard from folks is that it's very hard to get residential lenders to focus on someone's single family home property and the potential condoization of a small ADU on site, right? So that lender consent may not be as easy as it seems to someone not involved with this, right? So we think there's the opportunity there to facilitate the creation of ADUs by making that lien holder consent and interpret it in a way that actually works with how what's happening in the real world and the lender markets. The HOA consent. Obviously, HOAs are all different and have their own issues. How do we make sure that doesn't become a roadblock to the condo of ADUs? We already have recent state law that restricts HOA's ability to stop the construction of ADUs. A kind of a natural application of subsection G to AB 1033 is, how do we limit the HOA's consent as narrowly as possible so that it can't be used for the purposes of trying to stop the condo? But really, in many cases, the condo is what unlocks the ADU, right? So stopping a condo, could potentially stop the ADU from being constructed in the first place, right? So those are a couple of areas where we're looking at, and HCD again has been receptive, wanting to find creative ways to best interpret 1033 in light of this great statutory text in subsection G to kind of loosen this up even more. And so that's what we've kind of turned our attention to, and we'll be working on in the coming months. And would also love any feedback from folks who are familiar now with 1033 about other ways that they feel like applying it more permissively could help further the construction of ADUs in their jurisdictions. Thanks, Raphael.
Great. Thank you for that. And obviously there's a ton of moving parts to this, and it's a work in progress as things roll out. But we have questions, and we have some time now to take some questions from the audience. So we have our staff working to get those.
Okay. A couple people have asked, who are the cities, if any, who have already done the work necessary to allow this? And Raphael, have you got the list of folks, the cities that we've heard from jurisdictions, counties, and cities who are interested in it, and a couple of them have taken the first steps.
Yeah, so I think across the state, people are in very different places. I know down here in San Diego County, for example, it's a conversation that's been agendized for conversation. In cities like Chula Vista and National City, and San Diego's planning department is looking into how implementation would look for them, and express positive tones, but haven't taken any actual action. We've also heard cities that have made statements that they have no plans to implement at this time in San Diego County, like Oceanside. And then we have seen that Santa Monica City Council has taken action to direct their staff to implement it last fall, so that's in process. Other cities, Berkeley, San Jose, and other parts of the state have, are all along that spectrum where they're looking into it, they're working on it. But as of now, we are unaware of any cities that have actually implemented an ordinance that lets you convert an ADU condo as of today. There's several cities that are all working towards that. And they're all in different stages. And if you're aware of any cities that have agendized it, spoken about it, or are in conversations, feel free to let us know so that we can keep our list updated and make sure that we have accurate data as well.
Okay, great. And we have some of our panelists are directly answering questions. So folks, keep your eye on the Q&A there to get the answered questions as well. Can someone address there's a question in the chat about the step-by-step process. So if you're a homeowner, an applicant who wants to do this, it would be good to just have a quick rundown of the two scenarios where you have to build a new ADU to convert, or if you have an existing one. Who wants to handle that? I realize this is a California question, I think, given the state law, so. All right, I think we'll have to get back to that person. So I can try and you can correct me, how's that? So if you have not built it yet, then it seems as though Julie Alexander has brought up the fact that you could potentially actually pre-prepare with a condo process ahead of time, the right to develop, correct? Okay, but if you didn't do that, then you would find figure out your financing is always the first step for any project like this. And a possible idea would be to contact your lender first to try to obtain lender consent ahead of the game before you spent money on designing your ADU if you have not yet built it. And then if you obtain it, you go through the construction process, you construct your ADU, you contact a condo attorney who can create the map and the regime. A survey is probably done before that, yes, before the condo attorney is involved. Julie, Felsman, survey happens. When does the survey happen?
So in my experience, and maybe Julie, other Julie i.e. Julie can answer this, but the attorney acts as kind of a hub and really manages all the other things that are happening, which in Oregon would involve a survey and a reserve study if there are any common elements, and coordinating, making sure that the survey turns into the plat map that can be recorded, what they call a Mylar with the title company in Oregon. And the attorney is really the hub. So I recommend, once you figure out, I recommend start with your financing. If lien releases are required, then that's a very good place to start conversations, because it'll probably take a while to even get to the right person at your lender. If you need financing to build the ADU, then talk to a lender. That would be someone like me to just figure out, okay, where am I going to get the money if you don't already have it, and engage with your attorney next so that you can begin that process and have the attorney kind of hold your hand through it. There, at least, Julie, would you agree that it's you kind of run the show, right?
Yes. I often feel like the circus ringleader with the surveyor, lenders on both sides, right? The seller, the owner's lender, buyer's lender, title, insurance. I just want to chime in and say that I fully agree with both John and Julie talking about streamlined lender consent processes. In Texas, I should point out that although there is a state law that requires a lender consent, no one's checking it, and there are no teeth or penalties if you don't get it. So I'm not saying this is the best solution, but we are able to file condo regimes without a lender consent when the loan is going to be paid off. So if it's going to be paid off at closing, title and everyone just sort of knows that that's going to happen and moves forward without the lender consent. So it gives an option for people to move forward when the intention is to pay off the lien. And I think that if there's any policy changes that support that in a way that's not just ignoring it, that would be really good for owners.
Yeah, and I think that's like, I probably rushed through those slides because I was feeling pressed for time, but basically, the reason my friend Alex her attorney told her go get your lender consent was because she intended to sell a unit, and she can't put something on the market to which she can't get marketable title. And she had two liens. She had her first mortgage and her HELOC, and her attorney didn't know that she was going to be able to entirely pay that debt off more than with the sale of the condo. So with the sale of the front house. So when they figured that out, they were like, oh, okay, we'll stop. Sorry about that. You've been running around for no reason. She tried for quite a while to even get to the right people and couldn't get responses in one instance. And finally, they were just like, oh, never mind. You're going to pay it off. Who cares? And I don't know if we have a consent law in Oregon, but if the loan is going to be paid off, then it's an awful lot of work to go to for something that's sort of automatically going to happen. And in my experience, every small condo conversion I've been involved in, ADUs or multifamily, the the goal, the reason that they're doing it automatically involves paying off or obtaining new financing. And maybe because I'm a lender, that's more common in my world. But, if that's going to happen automatically, then if there can be some accommodation under the flexibilities that are allowed, under Section G to say, oh, if you're going to pay it off, then, cool, let's not jump through a bunch of unnecessary and very expensive hoops when we know we're going to be getting to this end game of these debts are going to be retired anyway, and I don't know how that would, wind up looking, but as a pragmatic matter, that will remove a significant obstacle for homeowners who are trying to develop it. Developers are fine. Developers, lenders know that they're going to be developing units that they're going to sell, and that's built into those types of, loans. It's an assumption, part of the deal.
Great. So I think I'll just end there by saying Casita Coalition is going to publish a handout on this, and that'll have the steps both for a jurisdiction and for an applicant in the different scenarios of that these conversions could happen. Linda, you've got your hand up.
Yes, quick addition. All the advice has been lovely and wonderful, and people are, both Julies are incredibly capable of answering these questions. I think just from looking at this from a government standpoint, if you're an applicant, I would say your very first step would be to check to see if your city allows it, because then you would go get a lawyer involved, get like a lender consent, and then your city may not allow it. So first check to see if the jurisdiction where you live in allows it, and then maybe with the help of a lawyer you can figure out like the HOA situation if you're part of a larger community HOA. But just flagging, you have to opt in.
Yeah, 100%. That's the first step. We are all so excited about this that we sometimes forget to mention it, but it is the first step.
Okay, I would just add a caveat that really is the answer to just about every one of these questions that are in the Q&A. It depends on local implementation, right? Each local, including the county, there's some questions on the Q&A about Prop 13 tax reassessment. The hope is that when an owner files a condo map, because ownership has not changed, change of ownership is what triggers reassessment on Prop 13, that the assessor will find a way to blend the two values and separately assess them under the same owner. Now, once those properties sell, they'll get reassessed for the amount they sell for at market value. But that's ultimately going to come down to county assessors and how they interpret Prop 13 in this case. So that's also one of those, it depends on local implementation answers. I saw that John had his hand raised.
Yeah, actually, it was really close to what you were getting at, Raphael, which is there was a question about, when do cities have to adopt a 1033 ordinance? Just to be there's a very critical issue. This in no way mandates local jurisdictions to do anything, right? This opens the door. As of prior to AB 1033, cities were not allowed to provide for condos of ADUs. Now the door is open for them to allow it. But I think that plugs into the larger issue, Raphael, in terms of so much of this is about the local jurisdiction, right? Yes, about the condo map. There was a question about, how do we make the lot split process faster? Again, that is on a local level, and this is what we've recommended to local jurisdictions, like make your subdivision process smoother for an ADU, right? Which, hopefully reduce costs and all that. The tax assessor, every tax assessor does their job a little bit different. And so, how is the local tax assessor going to take this on? I think it's interesting. It's this opens up local possibilities, but it requires our coalition and others to make sure that it does get implemented in a way that helps further the construction of ADUs.
Okay, thank you. Well, those are all the questions we have time for. I'm sure we could go on for another hour answering questions. It's such an issue, but we're on top of it. We're working with all the experts. We're working with all the policymakers. We started at the state level, and now we're taking a deep dive at the local level to get this across the finish line so that people can take advantage of this new opportunity in California. Thank you to all our presenters and our sponsors. And on behalf of the Casita Coalition, our thanks to you for attending today. We invite other ADU and middle housing professionals, community-based organizations, and homeowners to add your voice and join the conversation by becoming a member or donating to the Casita Coalition at casitacoalition.org. You'll find lots of resources on our website, including guidebooks on subjects such as pre-reviewed plans programs, garage conversions, SB 9, and many more. Links to our webinar library on our YouTube channel. Some of you have asked if this will be available. Yes, on our YouTube channel, so look for it there. And many more resources for both ADU professionals and homeowners. You can keep up to date on all our events and stay informed with ADU and middle housing news by joining our mailing list or becoming a member at casitacoalition.org. Thank you, and see you again next time.